JM quietly said hello and appeared worried and uncomfortable. Following day, when JM was in my care, he disclosed that he was fearful that Nicole, I think that's his father's partner, would see our encounter and that his father would be angry with him. Now, this is where we get the first twist. The first sentence is admissible.
Okay, right.
JM quietly said hello and appeared worried and uncomfortable. This is mom's affidavit.
Right.
DM is saying, he said, my child said hello to me. My observation is my child appeared worried and uncomfortable. Mom can testify to that. She's saying what she saw. So it's not hearsay. She's testifying what she actually saw and observed and what JM said to her specifically. And she's now testifying about it in court.
Yeah, that makes sense.
However, is back to the norm. It's inadmissible hearsay. That JM told me the next day that he was fearful that his dad's girlfriend would see us and that his father would be angry with him. Now we're back to hearsay. So in that statement, the first line is admissible because it is parent A's personal observations.
Yeah, that makes
sense. The second is inadmissible hearsay.
Right.
Okay, number 5. JM grew very stressed and anxious and stated he had to do the right thing and return to his father the next day. I could hear JM in the bathroom talking to himself, repeating, I think the best thing to do is to go home tomorrow. JM was so worried that even though we were having a wonderful time, he wanted to go. The ruling, this is admissible because parent A is observing JM. JM is saying and doing these things in the mother's hearing and in her sight. So in her affidavit, she's telling the court what she saw and what she heard. And this has happened right when she was talking to him. It's not like the child was saying, I was upset and angry when I was talking to dad. This is mom saying, my son was upset and angry. I was watching him. I heard him talking to himself in the bathroom. So this now becomes admissible evidence because the mom is testifying as to what she heard and saw herself. It goes back to the same thing we'd had before. If I saw you kill somebody, I can come into court to testify I saw you kill that person. She's saying, I actually saw my son do all these things, and this is what I heard him say. And because it's her own personal observations, then and how she's reading how her son was feeling, she can do that. So that statement is actually admissible.
So that means basically, if a child has a conversation with the parent directly, just in a very simple, direct parent to child conversation, then the parent can introduce and say to the court, this is what my child told me? Because this sounds like this is kind of what...
But if you're reporting it, but what she's doing is she's saying, I saw my son, he was stressed and anxious. Yeah. And the comment that he made was, it was not about reporting what he'd said to somebody else, or it wasn't one of the things that was actually in dispute between the parties. Okay. If Malcolm tried to come to court and say, my son told me he wants to live with me, you can't enter that into evidence as proof that that's actually what the son wants. Yeah. Mom is saying, my son was really, really upset. We had a conversation about why he was upset. This is what he said. But the key point, what's being proffered as what was true is her observations about him being anxious and upset. Right.
So you brought a really good point out, because just now you said if the mother had said, oh, JM said that he really doesn't want to be with his father, he just wants to live with me. Can you introduce? Then that I don't think the judge would allow, right? Because it's not just observation. It's really right. Kind of like the mother saying, see, my son doesn't want to live with his father. My son just wants to live with me. He even said so. He told me. That's not allowed. Right.
And you're right. And that exactly is what the rule against hearsay is I can't introduce that statement that was made out of court. And my son told me he wants to live with me as proof that he actually wants to live with me.
Yes. That's what I want to get at.
Okay. Yep. So now you're starting to get it.
I'm getting because in this case, the JM is not saying I want to live with my mom. I don't like my dad or anything like that. He's just stressed out. Like this is an observation of him being stressed out. Yeah. Okay. I get it. Okay. I get it. Okay.
You can edit that out however you would like.
Okay. Number 6.
Okay. We actually have one more, and I still think we're going to get it. Now, this is another interesting example.
Yeah.
It's a little bit different again. Yeah. What is it? Okay, a copy of the text exchange between JM, the child, and AM, the father, on December 30th is found in the respondent's document brief.
Right.
The father had asked the child where he was, to which the child replied, at Bill's house.
Right.
Dad then texted the child saying, you are not supposed to leave your home in Burlington. It's not good to be traveling around, son. Oh, please be safe.
Right.
And this is what, and again, so what the judge is saying, there's this whole series of text exchanges that were included. Remember, we had that discussion when we were talking about evidence about whether you should bring these things in or not.
Yeah.
There are problems with it as evidence, and they're like, you have to be able to prove that whether they're reliable and admissible. And Justice Mills' decision on this point was the text messages are hearsay because they're a conversation that occurred in writing between two other people, not the person who's swearing the affidavit being involved in it at all.
Right.
But the record meets the threshold of reliability and is therefore admissible. Even though it's hearsay, it is reliable because it's in a text exchange. It's in writing. It was put down. It was recorded. It's not just one person saying this is what happened. It's like almost like a business record at that point.
Right. Got it. Okay. Right. Okay.
Okay. And then again, it's for the purpose for which it is being introduced. So mom has attached a copy of this text exchange to just say, this is the exchange that happened.
Right.
Okay. Where it would be inadmissible hearsay is if the whole issue is whether the child was at Bill's house or not. Now, if mom tried to introduce this text exchange to prove that the child was actually at Bill's house, that would probably be inadmissible hearsay.
Oh, interesting. Okay.
But it is admissible because it is reliable evidence that this conversation did take place. And as long as it wasn't being introduced for the purpose of saying, yes, the child was at Bill's place when he shouldn't have been there, then it is still hearsay, but it is admissible because it's the form of a record and it hasn't been tampered, assuming they prove that it hasn't been tampered with and they do all the steps they need to in order to introduce this text information under the Evidence Act, which is the whole big deal about how do you introduce records as evidence anyway. But again, it's a slightly different twist on, okay, how do you apply the rules of admissibility? But all of these things are still focusing on parents trying to put things before judges at trial about what the child has said in out-of-court statements. And in what circumstances can a person that's not the child be allowed to testify to what the child said when you're actually in court? And that's what it does. It was brilliant.
Yes. Because I'm looking at number 6 here. And I'm just wondering why the respondent would have introduced this text exchange. Like, what is the point?
Okay, Dad didn't. Okay, this is where we got to go back to, we need the scorecard to figure out who the players are. JM is the child.
Yep.
AM is the father.
Yep.
AM is the applicant.
Yeah,
this is the respondent's document brief. So this is in the mom's document.
That's right. So why did mom introduce this?
Because she's trying to show what a jerk Dad is.
Okay. So
say this is a text exchange between my son and his father, and this is what his father said to him during this text exchange.
This is supposed to
say, but the judge says it's not somebody saying something to somebody else. This is in a text. It's on the dad's phone. It's on the mom's phone or the child's phone.
Yeah.
Obviously, this conversation did occur.
You just brought up a very interesting point that I was actually going to bring up. And that's the part about giving something weight. Like something can be, a certain piece of evidence can be admissible,
right?
Like could be given no weight. So isn't that in effect rejecting it?
No, what you're doing is saying, yes, I'm going to allow you to testify about this in this proceeding.
Okay.
But now when I'm putting all the evidence together and I'm weighing what one person says against the other, I am actually going to find that, yes, I allowed you to talk about this at trial. I allowed you to testify about it. But I'm not putting a lot of weight on what you told me. I think there's a lot of other evidence that makes a lot more sense to me. So I'm not going to do it. And the other thing that's really interesting too, when you go through some of the different texts and things about when they're talking about hearsay evidence.
Yeah.
Is they're just saying like there's so many, like, or again, even just evidence, like you're right. The first rule is it admissible? And then once you've got through, that's your first hurdle. Is it admissible or is it inadmissible? Once you get over that hurdle and it turns out, yes, this evidence is admissible, the judge is going to allow you to put that evidence forward at trial, then the question is, how much weight is the judge going to give to it? And again, there was actually another case that Shmuel just reported earlier this week, kind of on the same topic. And it just said, like, okay, if a judge is making a ruling on admissibility and how much weight to give to evidence, there's a really, really great comment by a judge that says, look, this is not a hard and fast rule. Just because you don't believe somebody who's giving evidence on one specific point doesn't mean you have to believe them on every point that they say. You might believe them on some points. You might not believe them on other points. You might fully accept and give weight to some of the things they say and give absolutely no weight to something else they had to say, even if you said it's admissible. Because that's what the judge's job is to assess credibility and figure out what's happening. And people are not going to lie all the time that they're testifying under oath, but they're not necessarily going to tell the truth all the time they're testifying under oath. So that's why the judge, it's not even saying, well, I think this person's a liar and I don't believe a single word they say. Has happened. What's more likely is saying, well, okay, on this issue, because of the other evidence and everything else, I actually accept what this person is saying on this point. But on this other point, nah, it's what they've said is admissible, but I'm not going to give it any weight because there's a lot of other evidence that seems to point in the other direction, or it's self-serving or whatever. So yeah.
I suppose about the lying part and the whole thing about lying, like when you're in conflict with someone and you're emotionally involved, I find from personal experience, I tend to kind of assume that the other side is lying, and I mean lying in the sort of the worst sort of like meaning that you can think of, right? Like you know, like when you're upset with somebody and when they're saying something that doesn't match your own set of facts, then you kind of like you make a judgment.
He knows that's not true, and he's
lying on purpose,
making this up right now deliberately.
Yeah, but sometimes I suppose it is possible that people see things differently, people perceive things differently, and sometimes it probably may be human nature that sometimes we see a certain set of facts and we embellish it to our own advantage. So I suppose that in some ways, I mean, a judge could accept or reject, evidence and rule on credibility, but I suppose it's not always that people are
You're not deliberately not telling the truth.
Yeah, it could be sometimes, or maybe they're if the person is tends to get confused, or they're very emotional and the way they perceive things is a little bit distorted. Like maybe the judge would go, well, or maybe, or in this case,
maybe what you heard and what you recall is distorted.
Yeah, or sometimes like even our memory, also our memory is fragile, so it's not always, you can't always rely on your memory. And in this case, this AM versus DM is actually quite interesting too, because it's got the additional dimension that the children, I think one of the children have they're on the autistic spectrum. Oh, both of them are.
Both of them.
Oh, yeah, that is an additional sort of difficulty, I think, now when it comes to.
Okay, so how reliable is it? Yeah.
Yes,
so
yes.
Children have been diagnosed with autism spectrum disorder and cognitive disabilities.
Yeah.
The older boy is admitted to lying to parents and teachers. The younger boy has lied to his family, to his teachers, and to the police.
Yeah.
He is highly suggestible and say whatever he feels is necessary to extricate himself from an uncomfortable situation.
Yeah.
And does the judge come up with that? From Ms. Goldhar's report.
Right.
And with the reports that were filed. Like again, this kid had children's aid called on his dad numerous times. Never any allegations made out. That he called the police to accuse his dad of committing all these criminal offenses. No evidence supporting that whatsoever. And it just happens. Well, I thought at one point we did talk about lying and like how to, like, what do you do if the other side is lying? And again, what we talked about is what I've always said, it would be, God, I would have loved hearing my client's side of the story, I would have just wanted to be a fly on the wall.
Yeah.
Being there, just quietly minding my own business, when to see an actual argument that my client is telling me who started it, what happened, who said what was it about, who was yelling, who was calm, who was mad, who wasn't. And being the fly on the wall, what an independent, neutral, third-party
Yeah.
observer actually is
Interesting.
going to see is probably not what either party actually remembers.
think
There've been all kinds
so.
of psychological tests done to prove that.
I think so. I think it's fascinating, isn't it?
Yeah.
Okay.